Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about drug addiction and sentencing. Cases that should have gone to the Supreme Court of Canada, but didn't. In the context of a case involving a manslaughter conviction, an individual who was severely addicted to drugs at the time that he committed the offense argued that the sentencing court ought to take into account the fact he had a drug problem as a mitigating factor on sentence, essentially arguing that a drug problem is a mental health condition and somebody's evidence of mental health issues affecting their commission of the offense can lead to a lower level of moral blameworthiness. The court disagreed and did not treat drug addiction itself as a mitigating factor on sentence. And I think the Supreme Court of Canada ought to have given leave to this issue and weighed in on this question of the degree to which drug or alcohol addiction can impact somebody's moral blameworthiness such that it can be considered a mitigating factor on sentence. While it certainly is often the case that judges consider that our people are addicts, they're usually considering that people are addicts not in mitigation for their actions because they committed them while they were high or while they were in the throes of their addiction, but instead because of rehabilitative actions they've taken since the offense, and that's aimed at one of the principles of sentencing, or as a result of looking at the entire context in which the offense was taken place, but not used as a mitigating factor. And with our developing understanding and our broadened range of acceptance for people and their mental health conditions, it seems incongruous with the way that we understand people with addiction to not be bad people who are doing things that are damaging to society, but people who are trying to cope with their traumas. And it is a mental health issue in the end. If it were any other mental health condition, the court would look at it as a mitigating factor. So if the Supreme Court of Canada is of the view that a drug or alcohol addiction isn't a mitigating factor that should be considered on sentence, then they should at least wade in to comment on why drug or alcohol addiction or any type of addiction is somehow different than any other type of mental health issue. And unfortunately, we don't have that guidance. The problem that this leaves us with is that many people who come before courts commit offenses as a result of addictions, whether it's in the throes of their addiction, whether it's to support their addiction, or whether it's because they need to do something that obtains them the things they are addicted to. And if we don't have a recognition of the mental health condition that is impacting their commission of the offense, then we really don't have a mitigating factor that truly recognizes a person's level of moral blameworthiness. Hopefully, the Supreme Court of Canada gets another opportunity to address this issue and explain why, if addiction is not a mitigating factor, it isn't, and alternatively, explain why it should be considered a factor in mitigation at sentence. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you for putting together these videos, and like, subscribe, share with your friends.